Good morning, everyone. Good afternoon, good evening, depending where in the world you might be. Today is February 3rd, 2022, and welcome to We'll Work for Food, the New Possibilities Hour. Our special guest today is my friend David Louie. David is coming to us from Hawaii, one of my favorite places on earth, and he's 2 hours behind, so it's 6 a.m. for him there. And it's a pleasure to have David here. David's talk today is going to be about from the desk of the Attorney General and telling about what it is like when you're involved with negotiation, settlement, the behind the scenes of what it is with state government, etc. David was the Attorney General of Hawaii beginning in 2010, and I'm sure he has lots of stories to tell. He actually has put it together, his stories in his book, which is available on Amazon, among other places. So let me just share. This is what it looks like, and I wanted to show the front cover of it for a special reason, because this is the front of this special desk. All right, the desk that you used as Attorney General, and it is an historic koa wood desk in Hawaii State Capitol. And so anyway, that's it for the show and tell for this part of it. And we'll go back to the regular part. David is a civil, or has been a civil trial lawyer. He's presently with, and if I butcher this, I apologize, Kobayashi, Sugila, Goda, and in Honolulu. And he's a mediator as well, an ADR professional. He has been a civil trial lawyer in practice for, he was 32 years when he became Attorney General. So at this point, more than 40 years, I would say then, all right? And David and I first met about 20 years ago, and it is indeed my pleasure to have him here with us today. His charity, or his food bank, is the Hawaii Food Bank, and Natalie's putting the link in the chat for you to be able to make donations to that. And then speaking of donations, we're coming up on $250,000, I believe. So where are we today then, Jeff?
Jean, thank you. I'm so happy to announce that our audiences have been so generous in contributing in honor of our wonderful speakers. So far, our generous audiences have contributed $234,383 to food banks worldwide.
Wow.
This is our 100th episode of the We'll Work for Food project. Natalie's been keeping track. So whether you're depending on what time zone you're in, you might be toasting with champagne, or you might have a protein smoothie the way I do, or the way Natalie does in France, or whatever you have in honor of 100 episodes. And Natalie, how fantastic it was that this is all your brainchild. You created it in the spring of 2020 at the beginning of the lockdown. Acknowledgements, thanks, gratitude to you, Natalie, for all that you've done. Thanks so much for inviting me to be part of it. I know Jean feels the same way. Jean, back to you.
Absolutely. What a difference one person could make in the world. So that's 1 to 2 million meals just from our humble group, and those are only the donations that someone has told Natalie about. So I'm sure there's much more that's been donated that we haven't even heard about. So anyway, thank you all for your generosity. And without further ado, David, the floor is yours.
Jean, thank you very much. Aloha, everybody. Good morning, and it's a pleasure to see you. Before I forget, let me just give a shout out to my friends who I see on screen: Sid Kanazawa, Chuck Crumpton, and Elliot Hicks. Great lawyers, mediators, arbitrators, and people. And Jean, of course, who I've known for decades. And thank you so much for the opportunity to just chat with you folks about my experience and see if any of it resonates with you. So what I'm going to do, I don't have a PowerPoint. I'm just going to talk. I'm a talking head, which is going to be sad, but I'm going to try and make it entertaining for you folks and tell you. And there's Mimi Castile, one of my great friends also. So anyway, I'm just like a lot of you guys. I've been a mediator, arbitrator. I've been a lawyer trying cases for 40 plus years. I started back in '78 and did a lot of stuff. Settled a lot of cases, mediated a lot of cases. And then 10 years ago, I got a rare opportunity. I was appointed to be the Attorney General of the state of Hawaii by Governor Neil Abercrombie. And it was a sideways move, in some ways a blind leap of faith, but I jumped into it, and I had the rare opportunity to take a high-speed elevator up to the C-suite, the executive offices of state government, where I got to make all kinds of decisions. I got a seat at the table. I was in the room where it happens. I got to meet with all kinds of people. I provided representation, counsel, advice to everybody in the state, from the governor and the state agencies and department heads, all the way down to the guys digging the trenches out in the streets, for everything. And the state has, it's the largest law firm in the state of Hawaii, and it has a tremendous reach and a tremendous amount of things on its plate. I got to do amazing things with amazing people. I got to meet national leaders from our great nation, and I even got to meet international leaders. So I got to do all kinds of things. It was the best job I ever had, ever. And Bill Clinton is rumored to have said, he was AG of Arkansas before he became governor and then president. And he once said, supposedly, this is what the lore of AGs is that it was the best job ever because you could do what you thought was right. And when people got pissed off at you, you would just blame the Constitution. Okay. And so that's what I got to do. Is I got to do these. It was a total fire hose experience. It was, I once had the rare opportunity to go visit a nuclear carrier, the USS Nimitz, in the RIMPAC exercises. We flew in, and then when we left, we got shot off by a steam catapult. 0 to 125 miles per hour in 2.5 seconds. It was better than any Disney e-ticket ride. That's a very old reference for the old people here. But it was terrific. And that's what it was like to be AG. 1 minute you're minding your own business, and the next minute you're flying at jet speed, and all kinds of things are coming at you. And then, I served for 4 years. Governor Abercrombie could not get reelected. I got to sit in the high councils and make all kinds of decisions. And then one day in December, my term ended by statute. And it was the opposite of being shot off the deck of the USS Nimitz. It was, in fact, when I flew in and got caught by the tailhook. 1 minute you're flying along at jet speed, and then suddenly, boom, you're jerked to a stop. It was over. The ride was over, but it was the ride of my life, quite frankly. And then I went back to private practice. And so one of the things that I wanted to talk about with you folks today is my experience and how, after I rebuilt my practice and how what I did as a AG made me a better lawyer, a better mediator, a better arbitrator. It made me understand the process a little bit more. I work as a mediator arbitrator with DPR, which is Dispute Prevention and Resolution in Honolulu. And some of this may be of interest to you folks. Now, some of you may think, wait. Government, that's a bunch of crazy people. Politics, these people are idiots and irrational. They have no clue what they're doing. And this is no way to run a country. Okay. But when you go into government, and some of you have, I know Elliot has, when you go into government, you find out that there are processes. Government is not a black box. It's actually very understandable. It's just different processes. And at its very heart, what we did in government, what you do as mediators and arbitrators, is the same thing. It's all conflict resolution. Okay. whether it's legislators trying to craft legislation or governors trying to implement ambitious programs, you're taking competing interests and trying to bridge the gap and resolve differences and solve the disputes and move on, and trying to do it for the common good, bringing people together with dignity and respect, and trying to, make a difference. And so, I've always thought, especially in Hawaii, where we have a large Japanese American population, and there used to be sumo matches on TV, sumo wrestling. I have always thought of government and politics as a sumo match. You have half naked, sometimes fully naked interests in a ring, pushing, shoving, seeking dominance, power, authority, money, influence. And that's what government's all about. But so is mediation and arbitration, just writ a little bit smaller, just not, as many people. And the rules are different. The rules are different. Being in litigation, mediation, arbitration, the rules are highly stylized. It's, if you were to compare it to government and politics, it's litigation is just like a boxing match with a referee. But politics, that's like a street brawl outside a bar. There are very few rules. And so, I had a lot of learning to do moving into that world. But my career as a lawyer helped me. It held me in good stead. And so it was a steep learning curve, but I got a great education. And now, before I talk about that education I got, let me talk and give a shout out to the Hawaii Food Bank. The Hawaii Food Bank is a terrific organization. A lot of people think, hey, you guys live in paradise. Everybody's rich. There's no problems in Hawaii. It's paradise. Well, somebody's got to do the job here. They got to ring the cash registers up. They've got to make the world go round. You've got tons of ordinary people doing extraordinary things to make our economy go. And when the pandemic hit, we already had a problem because it was like 1 out of 8 people in Hawaii had food insecurity. But when the pandemic hit, we really went to like 1 out of 6, 1 out of 5 people. It was, people lost their jobs, our economy cratered, and the food bank was there with all kinds of programs. I don't have to tell you guys that food insecurity is a huge problem. It's like number 1 of the foundational blocks of Maslow's hierarchy of needs. If you don't have food, you could care less about justice, okay? You could care less about solving disputes. You just want some food, and you are willing to lie, cheat, steal, and kill to feed your children. So food insecurity is huge, and what this organization does is huge, and what Hawaii Food Bank does is gigantic. So please donate to Hawaii Food Bank or donate to others. They play a critical role, just like all of you do, in keeping things moving and keeping our society moving and going along. So now let me tell you about what I learned in my time as AG. I had the privilege to resolve a number of thorny, long-standing disputes. And what I thought I'd do is just talk about a couple of them and talk about the process of government, as well as the process of dispute resolution, which I think, whether it's government, mediation, arbitration, or even litigation, it's largely the same. You have to understand the process first off, right? That was the first thing I had to learn was, well, what's the processes in state government? Politics is said to be the art of the possible. And that's really true. It is all about making the deal, but you have to make the deal. You have to go to where other people are. You can't just, shout in the wilderness about your viewpoint. Well, if you read Robert Caro's books about Lyndon Johnson, who was an enormously complex man, but a great president and did some great things. He was very critical of people like Hubert Humphrey, who would make wonderful sounding, flowery speeches, but could not get the legislation through. And if you can't get the legislation through, if you can't cut the deal, if you can't close the mediation and arbitration, well, then you haven't done anything, really. You've left people where they are. So it's really important for people who are going into government and mediators and arbitrators to totally understand the process, understand the rules, understand the dimensions, and really, this is the thing I learned, is you have to make sure that people who are participating understand that the process is fair and reasonable. Because if they don't believe the process is fair, then they're not going to be satisfied with the result. And that's one of the things about our system is, and I think mediation and arbitration, if people believe that they have been heard, that they've been treated with dignity and respect, and that they've had an opportunity to talk, then they can many times accept the result, even if it's adverse. And so my role in government was to move the process along. I had a particular role as the AG, I was advising people, but there are different roles for mediators and arbitrators, and you have to understand, what is your role? Are you an arbitrator? Are you the judge, essentially? Or are you an advocate, a lawyer, or are you a mediator? And whether, depending on what your role is, regardless of what it is, the important thing in my mind was to make sure that people understood that it was a fair and reasonable process. And one of the key elements that I think is really important that I had to learn and was, was something that I constantly worked on, and I think people as mediators and arbitrators have to work on, is engendering trust. If people don't trust you, it's not going to work. That's the whole deal about what makes commerce go around. And when people trust the process, when people trust that things are safe and that people will do what they say they will do, where the rule of law is involved, they will invest their time, energy, and confidence. But if you don't trust what's going to happen, you're in a third world country where there's a dictatorship and they might take your property, you're not going to invest. And the same thing in a mediator. If you don't trust the mediator, you're not going to tell the mediator what you really think. You're not going to tell them where your push points are and how you might do that. But I will say this, getting trust is not something that you get to do. It's earned. It's not, you can't command trust, you have to put yourself out there, tell people, all about yourself, and they might trust you because of your experience and your roles and because they want to, but they may not. And one important thing that I learned is that my role as a leader, and I think that's true of the role of mediators, is the difference between being a mountaineer and a mountain guide. A mountaineer wants to get to the top of Everest. It's all about individual achievement. But for a leader, if you're running a department, if you're running an agency, if you're mediating a dispute, your job is to get the group to the top of the mountain. It's not your individual aggrandizement. It is what's going on with the group. What are the dynamics? What's happening with everybody else? How are we going to get everybody to yes? Because, in a mediation arbitration, it only takes one person to screw it all up and to throw a monkey wrench in and say, no, I'm not settling. And then the whole thing falls apart. And arbitrators are like judges. There's an old saying I love, which is, whenever there's a trial, the judge is on trial as well as the parties. And that's true. And when there's an arbitration, it's the same thing. The arbitrator's on trial. Are you an honorable person? Are you trustworthy? Can you do, a fair job? So all these things are important. And one of the things I learned was that government attorneys are guardians of the process. They represent both the state interests but they also have an obligation to make sure that the process is fair and that the sanctity and the procedures are followed so that everybody thinks that the whole thing is a fair process. And I think mediators and arbitrators are the same. We're all guardians of the process. We are all making sure that people believe that the process is fair and reasonable and will result in some result that they can actually live with and that can happen. So, those are really important things as a mediator arbitrator. And when I was AG, you have to understand the problem. You have to try and understand the dimensions of the problem. You have to understand the people because they're the key. One of my friends who's Mike Turpin, he was Oklahoma Attorney General and he ran for governor, but unsuccessfully. But he always used to say was on election day, the needs of the people have to meet up with the candidates' qualities and what they deliver. And that's who gets elected on that day of election. And it's the same thing, I think, with mediation and arbitration. Can you meet the needs of the participants? Whatever they may be. They may be money, rationality, it may be ideology, it may be some emotional need. But, it's understanding the people, understanding who the decision makers are, getting them all in the room, and making sure that that happens. And that is critical in order to get to yes, in order to resolve a dispute. And so, those are all the things that I had to understand, which I think plays over to mediators and arbitrators. When I was trying to get compromises, who are the decision makers? Who do I need to talk to? Who can actually make a decision here? And will they focus on what we're talking about, or are they going to be distracted by something else? And then what are the reasons that they are doing what are the reasons? What are the factors? What are the hot button issues that will influence their decision-making process? One of the things Governor Abercrombie used to tell me was, people will do things for their reasons, not yours. And that's true. You can talk till you're blue in the face, and if they're not buying your reasons, well, sorry, you're not getting agreement. Okay. And so the question is, well, how are we going to find out what are their reasons? And that, when I had to go negotiate on legislation or talk to the governor or talk to agency heads, I wanted to know, what's going on? What are you trying to do? What are your reasons? What are the hot button factors for you? What are the most important factors? And what are all the other factors that exist? And so you want to find those things out. And unless you can do that and find out and understand their reasons, and then maybe bring them around to your reasons, maybe talk to them about the rationality of their reasons, or try and change the narrative as to the value of their reasons and whether or not keeping the dispute alive and being able to have their reasons and talk on a street corner and give their point of view is less valuable than solving a dispute and moving on with their lives. Unless you can do that, you're not going to have a deal. And it's all about getting the deal and closing the matter. So the other thing I will say is that you're going to have tests. And one of the surprising things to me is going into Attorney General's office was the tests. The tests that come at you and you're never quite knowing where they're going to come from, and but they're there. And I had a lot of tests. I constantly had politicians and lobbyists testing me. What are you made of, kid? Can I push you around? Can I achieve dominance over you? Can I make you do what I want you to do? And so, people would do stupid things. They would want me to do illegal things. They'd want me to cut corners. They'd want me to give special favors. And I was like, no, I don't think so. Okay. And so, you're going to get tested. I got tested. I got tested constantly. There were a lot of them. And you'll get tested as a mediator and as an arbitrator. You know, people are going to push your boundaries, and you have to expect it because, you know, in government, there's a lot of money, there's power, there's influence, and there's all kinds of things at stake. And so, unfortunately, people will say or do things that, you know, you wouldn't countenance, you wouldn't allow between friends. But that's the whole thing. These guys aren't your friends. And in a mediation and arbitration, they're not your friends. You're an impediment to them getting what they want. All right. And so they are going to push and they're going to try and get you to do something. And so you just have to understand it. You know, there's an old saying, it was credited with Harry Truman. If you want a friend in Washington, get a dog. Okay. And you know, that was one of the things I learned. Like, I'm doing my job, you're doing your job. We might be friends later, but I'm not going to worry about it. Let's do our jobs, okay? You want to test me? Fine, bring it on. You want to try and play me as a mediator and not tell me the real story? Shame on you, because you'll lose the opportunity to settle, because I'm really trying to help you. But if that's what you want to do, if you want to have me be your advocate and go over and beat the other guy on the head and say why you're right and he's wrong, well, guess what? That's what he wants me to do. And if that's what we're going to be doing, well, then we're just going to be talking past one another. We're not going to get communication. We're not going to get understanding, and we're not going to get a resolution. So, you know, just remember there are going to be those tests, and they're going to come along, and so you have to be prepared, but don't take them personally. You know, don't take anything personally, because the stakes are high, and you just have to understand that is the process, and you just have to keep working at it to make people understand it's not a zero-sum game. Even if it's just about money and it's an insurance company and they want to give less and the plaintiff wants to get more, it's still not a zero-sum game, because there's a win-win there where everybody moves on. The insurance company gets a win because they stop spending money for defense attorneys. They close their books. The plaintiffs move on because they get something. Maybe it's not every dollar they want. Maybe it's not total validation that they wanted, but they get an opportunity to be heard and they get to move on with their lives. Because there's a lot more important things than being in a dispute and fighting. Okay. It creates stress. It creates anxiety. It's bad for your health. And so there's always a win-win. There's, you know, and that's part of our job as mediators, is understanding it's not a zero-sum game. So now let me talk about one of the signature things that I got to do that I was really proud of in state government was I got to be involved in a lot of things, but one of the biggest was legalization of same-sex marriage. And that was huge for me because it was personally satisfying, because it was a social justice issue, a civil rights issue, and an issue of basic dignity and humanity. And you know, today a large number of Americans and people in Hawaii think that everybody should be able to marry the person they love, and spend their lives with them. But you know, this was a long, hard fought kind of thing that spanned decades. And for many people, you know, when we were all growing up, there was lots of discrimination against gays, and it continued on. You know, the Hawaii Supreme Court was an early leader in this fight, because it came out in 1993 with the first state Supreme Court decision that said, hey, wait a minute, this is just like Loving versus Virginia. This is a matter of basic human dignity, and the equal protection provision of the Constitution, the Hawaii State Constitution, governs this, and you cannot discriminate against gay and lesbian couples. Oh my God, you would have thought the the sky was falling because the backlash was tremendous back in 1993. State legislators denounced the Hawaii Supreme Court. Everybody rushed to go pass a constitutional amendment so that their discrimination could be enshrined at the highest levels of the Constitution, so then they could fight back against the Equal Protection Amendment. And it was a terrible, terrible time. Even in Hawaii, we had a movement to have a constitutional amendment. But over 20 years, over time, things changed, and eventually, you know, the U.S. Supreme Court on litigation ruled that was unconstitutional. In the Windsor case, in the Hollingsworth case, and later on in the Obergefell case, and these were important rights. So I was happy to be involved in this. My first involvement, and I wanted to tell you the story about this, came when I had to make a trade-off of my own personal vanity, which is huge, you know, as Gene knows, and my bully pulpit and talking about things that I thought was right. I had to trade that off in order to get a deal done. And so here's what happened. Before the Supreme Court, the U.S. Supreme Court ruled, a group of plaintiffs brought another lawsuit in Hawaii to declare the discrimination unlawful and unconstitutional. And so we had to defend that. As the AG, you're called upon to defend the laws. But there was precedent from Governor Schwarzenegger and Jerry Brown in California. When they were confronted with that choice, they said, you know what? No, we're not going to defend that. I, as the AG, will not defend that. And Eric Holder, when he was confronted with the Windsor, you know, and President Obama, they were confronted with the Windsor case as that was moving up. Eric Holder said, I'm not going to defend that law. It is wrong. It is unconstitutional. And so I wanted to do the same thing. And Governor Abercrombie says, let's stand together. We'll do this. We'll come out strong. We're not going to defend the law. And I said, that's great. Let's do that. And then I went to talk to some legislators, the legislative leaders. Now, the legislative leaders, Senate president, you know, vice president, and House, and all those guys, they're very jealous of their authority to pass the laws and make policy. And they don't want people saying, no, your laws are unconstitutional. So they were concerned about this. And they said, well, you know, a couple of them said to me, you know, if you do that, I'm going to jeopardize, and I'm not going to let through another big deal you have going. And I had a big deal going. I had just concluded some landmark negotiations to settle a huge Native Hawaiian dispute on monies that were owed to a Native Hawaiian state agency by the state over crown lands, revenues from ceded lands, which are called crown lands, which had been taken in the illegal overthrow of the Hawaiian kingdom. You know, Hawaii is an interesting place because it once was a kingdom. It was illegally overthrown by a small group of planters and citizens with the complicity of the United States government, who annexed Hawaii, and they took hundreds of thousands of acres that you know were used, and a bunch of them were given back to the state, and so people there was monies due from the rent from those, but there was a dispute, and I got to tell you, Native Hawaiian issues. Those were the most complex, most fraught issues. And I know a lot of people deal with Native Americans and Native Alaskans, and they're very similar. But, you know, Native Hawaiians are a minority in their own homeland now. Maybe 10% of the people, if you identify one single race, it goes up to 27% because there's been a lot of intermarriage when you identify two races. But Native Hawaiians have been treated badly over the years. They have not shared in the riches and the prosperity that other groups have gotten out of Hawaii. And so there's a palpable sense of grievance and disenfranchisement, and it's a problem. These are very complicated issues. So anyway, we had gotten this deal. We were going to give the agency, $200 million of prime real estate in Honolulu, in lieu of giving them $400 million of cash that they wanted and that they thought they were entitled to. But by state law, if you're going to transfer land, the legislature has to approve it. So the legislature told me, guess what? Your big deal is dead if you want to do what you want to do and not defend us on same-sex marriage. And I thought, huh, okay. How are we going to get out of this thicket? All right. And the solution, my solution, was a little bit out of the box, and I always commend people for out of the box thinking. I was able to find a way because of the uniqueness of the Attorney General's office. By statute, the Attorney General can represent everybody and has to represent everybody, okay? But we don't have the same conflict of interest rules for the Attorney General. It is a unique exception. And because the plaintiffs in that case had sued both the governor and the director of health, I said, well, how about this? Governor, you attack the law. You say it's unconstitutional, it's wrong, we should not discriminate. I will have a team and we will defend the law because we're supposed to defend laws, and I won't do that. And so we agreed on that. I got the legislative leaders to agree to that. They supported the OHA deal. We got that through. It was a big deal. I was really happy to be involved in that. And we moved forward on same-sex marriage. And then after the U.S. Supreme Court ruled, the governor called a special session. We had all kinds of testimony. We had demonstrations. It was noisy. It was raucous. And well, I got to testify. I testified that it was a pivotal moment in Hawaii history, and it was important to do the right thing. But it was back and forth. There were demonstrations with busloads of people with megaphones making noise at all hours of the day and night. And then finally, the bill was passed to legalize same-sex marriage. And the governor read a letter at the signing ceremony. It was very moving about how one of his family friends said, those who were invisible are now visible. You know, people had come out of the shadows, essentially. And I thought it was an important moment. And so I was really proud to be part of that. But the fight was still not over. An immediate lawsuit went in to challenge that. I went down, argued the motion to dismiss, got it thrown out, and we were upheld. And fights still continue. But let me tell you the lessons I learned from that. First, the special session was critical, okay? Getting the people to focus on a single gigantic issue, not in the regular session, was incredible. And that's the same thing for a mediation. You got to get the people in the room if you can. You know, Zoom is okay, but it's not quite as good, you know, because they're not as focused. They're still distracted from making a deal and cutting a deal. And then the second thing that I learned was getting the OHA deal done was really huge. So we could go forward with that lawsuit and the OHA settlement, the Office of Hawaiian Affairs settle. And I was able to meet the needs of the legislative leaders so they would not kill my other deal. My vanity, as big as my ego is, could go by the wayside. And so it's important to do that and to have a fair process and to have something where people got to have their say. They were treated with dignity and respect. They all got their chance to testify. And in general, you know, unlike President Trump, and I know there's some people who support President Trump, but unlike people who think that election was stolen and won't accept the result, most people, if you go through a fair process like an election or a mediation or an arbitration, you'll accept the result, even if it is adverse. And so those are many of the things I learned. I had lots and lots of other things. We were able to do a conservation easement, get a deal in. I parachuted in to at the last minute during the legislative session to cut a deal and get $40 million of bonding authority done in order to protect 665 acres up at Turtle Bay and stop 4,000 housing units and 5 hotels from being built. But I had a very short time, and so I was able to cut the deal with the opposing side and get the legislative approval for that. That's where I saw the sausage being made in the back rooms, where on the very last day of session, I had to go sit there and drink with a bunch of legislators who were celebrating while I waited to be summoned up to talk to the Ways and Means chair and the House Finance chair about the final language to get our project through. Those are just some wonderful stories. But what I learned in government from all of that experience was that, you know, it's a big job, and I think it's important that government solve big problems, and it's the best vehicle in my mind to solving big problems. And mediators and arbitrators are a great way to solve problems, better than courts, which are overwhelmed and slow. So it's really important what everybody on this call does, I know. The other thing I learned is that, you know, civic engagement and civic virtues and the common good are huge, and that we are best when we're all acting together and we're all trying to solve a problem rather than throw rocks and demonize the other side. And although it's hard to recognize the basic humanity in other people, that's what you have to do, and you have to treat them with respect and dignity in order to get a deal. And I will say this, governing is hard. It's not for the faint of heart. Mediating is hard, not for the faint of heart. A lot of emotion, especially in family disputes. But even in even in money disputes, there's a lot of emotion. And so it's important that you recognize the cycles, the social dynamics, the timing of those things, and factor those in and try and get the deal done, and help to demystify the process. So that's really what it is. The other thing, and let me just mention very briefly what I learned about leadership, which I think is important, because I think as mediators and arbitrators, you are all leaders, and many of you are leaders in your community. I think it's important, if you put yourself out there and let people know what you're doing and why you're doing it, they will appreciate it. One of my friends ran for Congress, John Radcliffe, who passed away recently, a great man. He ran for Congress and he didn't win. But after he ran for Congress, people said, you know, that was a gutsy thing to do. We really want you to come along and help us do these other things. And so letting people know what you do is really important, and stepping out of your comfort zone. The other thing that I learned, and this was a story I got from Chuck Breyer, who's a U.S. District Court judge, the brother of Stephen Breyer, the Supreme Court Justice. Chuck Breyer told me this story about a legendary consigliere lawyer in California who used to carry around a small pocket notebook. And people would ask him for favors all the time, and he would write it down in his notebook. And then the secret that he had was trying to do something immediately. Because if somebody asks you for a favor and you say, sure, I'll take care of it. And then if you pick up the phone right there, or you do something that day and then you get back to them, they're going to think, God, that guy really cared about me. I meant something to that person. Even if you don't get success, and if you get success, my God, you are a magician, okay? And the curve of gratitude is way up there, way up there. But if you wait a week, if you wait a month, if you wait until that person calls you and says, hey, were you able to do this thing for me? Even if you got the best result, the curve of gratitude is down there. Okay? And it's all about meeting the needs of people. So I would just say, when you're going to do something, strike as soon as you can. Do it and act. And that's, mediators and arbitrators, act on what you think are the key points. So let me pause there. I'm gonna stop talking at you guys and try and talk with you. Gene, Jeff, if you guys want to throw questions at me, I'm seeing a couple of questions here. One from Karen Orlin about, and if it's okay, Gene, nod. Just tell me. I'll go ahead and just
Go ahead.
Some of
Sure,
these
go ahead.
questions. The question from Karen is, how have you successfully engaged in discussion with opposition that refuses to disclose reasons and facts underlying the opposition's position? Terrific question. Because, like I said earlier, people sometimes they want you to go beat up on the other side. And so, the first thing I do in these situations is I ask them, well, educate me, help me out. What are your key factors? What do you need to make a decision? What are the things that are important to you? And are there some non-rational or are there emotional reasons or people reasons or things that are a little bit, not as dollars and cents? And what would make you, move your position if you found certain things out? But then I also pose that question to them and say, what do you think the other side's hot button issues are? Tell me about them. And it's in the process of engaging them in trying to help resolve the dispute that I have found some success, not total success. I've cratered a bunch of mediations. I have been unsuccessful, unfortunately. Now, when you're an arbitrator, you just get the rule, so that's a good thing. But as a mediator, it's all consensual, and so you've got to bring the people to the point where they agree. And I think by engaging them in the process and helping them understand what you're trying to do and how you can talk to the other side and try and get consensus is something that I would recommend. It may or may not work. I will say this. I had this. I had a mediation a little while ago, and I just couldn't believe the position of the other side, or of one side, and I just thought it was totally irrational. And I think it was irrational. And finally, I said, "Well, guys, I'm going to declare impasse. I don't think you guys have evaluated this correctly, and I'm going to tell the other side that it's over. We're done." And about and the lawyer says, "Whoa. Why don't you hang on? I'll call you back in 15 minutes. And then they called me back and said, "Oh, come on, don't give up. Well, we can make a deal." And I said, "Well, look, you guys are taking some of the hardest line positions. You're not budging. You're not moving. You're not even telling me anything privately, okay, about your willingness to move. I can't help you. I'm of no use to you, and I don't want to waste people's time." And I've seen judges. Now, the federal judges get to do this. There was a federal judge, now retired, who used to come into the room and he'd say, "You people are wasting my time. I don't have time for your silly, stupid little posturing and your silly, stupid little dispute. So unless you get real, I'm out of here. I'm going to give you 5 minutes." And we would go, "Oh, that's interesting. That was an interesting approach." You don't get to do that as a mediator. But It was interesting. Okay. Next question. I hope, Karen, I hope that answered your question. Greg Whitehair has a question. How do you manage your emotions when you see your valuable initiatives as AG either dropped or reversed by successors? Greg, that's a great question. Love it. First, when you're AG, you get to sit in the seat, but when you're not AG, sometimes you have to accept defeat. And if your successor comes in and reverses your decision, then that's the process. The process is we switch out every 4 years and somebody else gets to make the decision. And if you want to change that, then you got to go in and lobby and get legislation or go meet with somebody and do it. But how do you manage your emotions? I think the way you manage your emotions is you just, put it on the side. You can't get too invested in these things in the sense of being emotional about it. You still have to be rational and understand it's the process. And don't let, yes, there were a number of things. There were some things that happened with my successor that I went, oh yeah, I wouldn't have done that. But it was his job. I got to sit in the seat. I got to make the policy decisions. I got to make the litigation decisions. The great thing is that the statutes in Hawaii give the AG the power. And so there were a number of times when I had to tell powerful people, no, we're not doing it your way. We're doing it my way. And that made some of them very unhappy, very unhappy. But I had the statute. I had the Constitution. What were they going to do? And so when I'm sitting on the opposite side of that and the new AG is telling me, David, no, that stinks. I don't like your position, your rationale. I just had to accept it. So that's, I think, the way to manage these emotions. And also the other thing is I try not to get emotional on things. I try not, it's a process, and it's it's important when I was a trial lawyer, never to let the opposition know what I was thinking, not to wear my emotions on my sleeve, even when I took a body blow, even when something bad happened. It was like, poker face, poker face, poker face. Don't frown. Don't let them know how badly you're hurt. Okay. And so that's what I think I'd say. Gene, any other questions?
Wow, I'm going to remember that mountaineering example. Thank you. There's nothing more in the chat. Did anybody want to raise their hand and ask a question? Otherwise, no. Well, then I'll ask one here. David, over the years, we've seen the state AGs settling the tobacco cases, and now I think they've got the opioid cases going. When you're in settlement negotiations on matters like that, how different are they from when you're in settlement negotiations over, some commercial litigation matter, for example? That's
a great question, Gene. And so I'm now representing some of the opioid manufacturers, defending the lawsuit by the state AG. And so I understand kind of both sides of that equation. When I was sitting in the chair, basically my touchstone for decision making was, what do I feel is the right thing to do for the most people, for the state? The perspective that I tried to have was, and it's different. Kind of when I became AG, I thought, well, I don't have a single client now whose interests are paramount and that I have to subsume my rationale. My client is all of the people of Hawaii, everyone, the entire state, and it's the state, and it's the process, and it's the whole thing. So I have to try and do what I think is right. And that was like Bill Clinton said, do what you think is right. Okay. Now you have to be guided by the law and the Constitution and the decisions and the statutes. But I tried to do what I thought was right. And so that would factor into my decision-making process on how I resolve disputes. I mean, one of the things that was great for being a litigator to come into the position is that I had a lot of experience in analyzing litigation and analyzing positions and then settling disputes and trying to understand that if I thought people were being irrational or doing the right thing. So in sitting in the chair, I think I tried to bring as much of that to bear and negotiate. You know, I would negotiate with legislators over policy matters. I would negotiate with the governor over what he was doing and how I thought, you know, sometimes he needed to modify his position a little. But still, I was trying to help him as long as it was constitutional and statutorily allowed. And so I think you just have to, you know, what's your perspective? The perspective was what's best for everyone. And as long as I can do that legally, that's kind of where I did that. And that's how I negotiated and tried to take positions for the state in resolving its litigation.
Basically, because the people of the state were your clients.
Yes.
And yeah, so, well, that's fascinating. Jeff, did you have any questions?
Greg's got one more here.
Okay.
Greg's, how did you work with the other AGs when multiple states took up a litigation position? What were the politics of being on a team with California or Texas? Great question, Greg. So and I'm going to make this really short because we've got a hard stop and Jeff has got stuff. I participated in the National Association of Attorneys General, bad acronym, NAG, but all the attorneys general would get together and we would do multi-state litigation together. And sometimes we would agree, sometimes we wouldn't. And so it was a consensus process, just like a mediation, just like any other group process. You had to bring everybody along. And so I will say California and Texas were kind of the big dogs, and sometimes they went their own way. But we tried to be collaborative, and that was one of the great joys. I worked on the national mortgage crisis, and I continued to see the tobacco litigation aftermath through, and so that was very satisfying. And I think there's 2 minutes left, and Jeff, I understand you've got some closing remarks, so let me turn it over to you.
Well, let me thank you, David. That was a fascinating and stimulating presentation. Your insights from experience it's information we couldn't get anywhere else. So thank you very much. We encourage everybody to contribute to the Hawaii Food Bank or another food bank that's important to them. If they're in a financial position to be able to contribute, please report your contributions to Natalie so that we can add it to our running total and perhaps make David Louie the answer to that unbelievable bar trivia question that will go down in history for generations. Who is the Will Work for Food speaker who put us over $250,000? Make David Louie the answer to that trivia question. Thanks again, David. Jean, back to you.
Yeah. Okay, great. Thanks again, David. I've got the Hawaii Food Bank website up on my other computer, and you know, it says nourish our Ohana's family, right, in Hawaii, and donate in the new year and help end hunger for tomorrow. I like that line of theirs too. So anyway, this is the Will Work for Food Ohana, and it's a pleasure again this week as in every week, and thank you so much for being here and for whatever donations you may be able to make. Have a great week. Thank you, David.
You all.
Thank you.
Mhm.